Welcome to IPcopy. Today we are going to be discussing the impact of Brexit on design rights in the UK and Europe, as well as asking what changes might happen as a result of Brexit. We need to ask when those changes will come into effect. There will be a key switchover date for IP, which we will be referring to in this video as exit day. The exact date of exit day depends on the manner in which the UK leaves the EU. In the event of a no-deal Brexit, where a withdrawal agreement has not been agreed by both sides, the UK will leave the EU without any transition period. In this case, exit day will be the end of the Article 50 period. Currently, the end of the Article 50 period is either the 12th of April 2019 or the 22nd of May 2019, though this date could potentially be extended again. If the withdrawal agreement is agreed by the EU and ratified by the UK, this provides for a transition period during which the UK will no longer be part of the EU, but will still be bound by EU rules. In this scenario, exit day is the end of this transition period, currently the end of December 2020, though potentially this date could also be extended. The exact date of exit day therefore won't be settled until we know whether a deal is reached. But whenever it is, the effect on design rights will be the same. So what will happen to registered community designs, or RCDs, after exit day? Well, after exit day, RCDs will no longer provide design protection in the UK. This means that when filing a new RCD after exit day, it will be necessary to obtain separate UK and EU registered designs in order to get protection across the territory that is currently covered by a single RCD. As for RCDs that have already been filed on exit day, these will be dealt with in two different categories: those already registered and those still pending. RCDs that are already registered will be cloned onto the UK register at no cost to the rights holders. These cloned designs will be given the same rights as existing UK design registrations, and all existing dates such as filing dates and priority dates will be maintained. Pending RCDs, which includes those subject to deferred publication, will not be cloned onto the UK register automatically, but there will be an option to refile these rights in the UK within 9 months of exit day to retain UK protection with the same filing date. These applications will incur the usual costs set out in the UK IPO's application fee structure, and they will undergo examination by the UK IPO in line with standard design procedures. Brexit will also impact unregistered community design rights, or UCDs, which arise automatically when a design is first disclosed within the community. All UCDs existing prior to exit day will automatically be given a similar effect in the UK for their remaining period of protection. Where a UCD comes into existence after exit day, that UCD will no longer cover the UK. There is a UK unregistered design right. However, there are some design aspects, such as colour and ornamentation, that would be covered by a UCD, but not by the existing UK unregistered design right. To cover this gap, the UK government will introduce a new UK unregistered design right called a supplementary design right, covering these design aspects. However, the country of first disclosure is important to the existence of these unregistered designs. So if unregistered design rights are important to you in the UK and Europe, you should consult your legal practitioner for further advice. Finally, Brexit does not impact Keltie's ability to continue to represent clients in the EU. Our Irish office remains in the EU after exit day, meaning we continue to be able to act before the EU IPO on all design and trademark matters. We hope this video on Brexit and Designs was useful. Look out for IPcopy's other videos in this series on patents and trademarks.